Constitution of India, Part 21, Temporary, Transitional and Special Provisions, Article 369 to 395. Article 369. Temporary power to Parliament to make laws with respect to certain matters in the state list as if they were matters in the concurrent list. Notwithstanding anything in this Constitution, Parliament shall, during a period of 5 years from the commencement of this Constitution, have power to make laws with respect to the following matters as if they were enumerated in the concurrent list, namely trade and commerce within a state and the production, supply and distribution of cotton and woolen textiles, raw cotton including ginned cotton and unginned cotton and kapas, cotton seed, paper including newsprint, foodstuffs including edible oil seeds and oil, cattle fodder including oil cakes and other concentrates, coal including coke and derivatives of coal, iron, steel and mica. Offences against the laws with respect to any of the matters mentioned in Clause A, jurisdiction and powers of all courts except the Supreme Court with respect to any of those matters and fees in respect of any of those matters, but not including fees taken in any court, but any law made by Parliament, which the Parliament would not, but for the provisions of this article, have been competent to make, shall, to the extent of the incompetency, cease to have effect on the expiration of the said period, except as respect things done or omitted to be done before the expiration thereof. Article 370. Temporary provisions with respect to state of Jammu and Kashmir. Notwithstanding anything in this Constitution, the provisions of Article 238 shall not apply in relation to the state of Jammu and Kashmir. The power of Parliament to make laws for the said state shall be limited to those matters in the Union list and the concurrent list, which in consultation with the government of the state are declared by the President to correspond with the matters specified in the instrument of accession governing the accession of the state to the Dominion of India, as the matters with respect to which the Dominion legislature may make laws for that state, and such other matters in the said list, as with the concurrence of the government of the state, the President may by order specify. Explanation. For the purposes of this article, the government of the state means the person for the time being recognized by the President as the Maharaja of Jammu and Kashmir, acting on the advice of the Council of Ministers for the time being in office under the Maharaja's proclamation dated the 5th day of March 1948. The provisions of Article 1 and of this article shall apply in relation to that state. Such of the other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify, provided that no such order which relates to the matter specified in the instrument of accession of the state referred to in paragraph 1 of subclass B shall be issued except in consultation with the government of the state. Provided further that no such order which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of that government. If the concurrence of the government of the state referred to in paragraph 2 of subclass B of class 1 or in the second proviso to subclass D of that clause be given before the Constituent Assembly for the purpose of framing the Constitution of the state is convened, it shall be placed before such assembly for such decision as it may take thereof. Notwithstanding anything in the foregoing provisions of this article, the President may by public notification declare that this article shall cease to be operated or shall be operated only with such exceptions and modifications and from such date as he may specify, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. Article 371. Special provision with respect to the state of Maharashtra and Gujarat. Notwithstanding anything in this Constitution, the President may by order made with respect to the state of Maharashtra or Gujarat provide for any special responsibility of the governor for the establishment of separate development boards for Vidarbha, Marathwada and the rest of Maharashtra, or as the case may be Saurashtra, Kutch and the rest of Gujarat with the provision that a reporter on the working of each of these boards will be placed each year before the state legislative assembly. The equitable allocation of funds for development expenditure over the said areas subject to the requirements of the state as a whole, and the equitable arrangement providing adequate facilities for technical education and vocational training and adequate opportunities for employment in services under the control of the state government in respect of all the said areas subject to the requirements of the state as a whole. Article 371A, special provision with regard to state of Nagaland. Notwithstanding anything in this constitution, no act of parliament in respect of religious or social practices of Nagas, Naga customary law and procedure, administration of civil and criminal justice involving decisions according to Naga customary law, ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. The Governor of Nagaland shall have special responsibility with respect to law and order in the state of Nagaland, so long as, in his opinion, internal disturbances occurring in the Naga Hills, Tensang area immediately before the formation of that state continue therein, or in any part thereof, and in the discharge of his functions in relation thereto, the Governor shall, after consulting the Council of Ministers, exercise his individual judgment as to the action to be taken. Provided that, if any question arises whether any matter is or is not a matter in respect of as respects which the Governor is, under this subclause, required to act in the exercise of his individual judgment, the decision of the Governor in his discretion shall be final, and the validity of anything done by the Governor shall not be called in question on the grounds that he ought or ought not to have acted in exercise of his individual judgment. Provided further that if the President, on receipt of a report from the Governor or otherwise is satisfied that it is no longer necessary for the Governor to have special responsibility with respect to law and order in the state of Nagaland, he may by order direct that the Governor shall cease to have such responsibility with effect from such date as may be specified in the order. In making his recommendation with respect to any demand for a grant, the Governor of Nagaland shall ensure that all money provided by the Government of India after the Consolidated Fund of India for any specific service or purpose is included in the demand for a grant relating to that service or purpose and not in any other demand. As from such date as the Governor of Nagaland may by public notification in his behalf specify, there shall be established a regional council for the Tensang district consisting of 35 members, and the Governor shall in his discretion make rules providing for the composition of the regional council and the manner in which the members of the regional council shall be chosen, provided that the Deputy Commissioner of the Tensang district shall be the chairman ex officio of the regional council, and the vice chairman of the regional council shall be elected by the members thereof from amongst themselves. The qualifications for being chosen as and for being members of the regional council, the term of office of and the salaries and allowances, if any, to be paid to members of the regional council, the procedure and conduct of business of the regional council, the appointment of officers and staff of regional council and their conditions of service, and any other matter in respect of which it is necessary to make rules for the constitution and proper functioning of the regional council. Notwithstanding anything in this constitution for a period of 10 years from the date of formation of the state of Nagaland, or for such further period as the Governor may, on the recommendation of the regional council by public notification, specify in this behalf, the administration of Tensang district shall be carried on by the Governor. Where any money is provided by the Government of India to the Government of Nagaland to meet the requirements of the state of Nagaland as a whole, the Governor shall in his discretion arrange for the equitable allocation of that money between the Tensang district and the rest of the state. No act of the legislature of Nagaland shall apply to Tensang district unless the Governor, on the recommendation of the regional council by public notification, so directs, and the Governor in giving such direction with respect to Any such act may direct that the act shall, in its application to the Tensang district, or any part thereof, have effect subject to such exceptions or modifications as the governor may specify on the recommendation of the regional council, provided that any direction given under this subclause may be given so as to have retrospective effect. The governor may, by regulations for the peace, progress, and good government of the Tensang district, and any regulations so made, may appeal or amend with retrospective effect, if necessary, any act of parliament or any other law which is for the time being applicable to that district. One of the members representing the Tansang district in the Legislative Assembly of Nagaland shall be appointed Minister for Tansang Affairs by the Governor on the advice of the Chief Minister, and the Chief Minister, in tendering his advice, shall act on the recommendation of the majority of the members as aforesaid. The Minister for Tansang Affairs shall deal with and have direct access to the Governor on all matters relating to the Tansang district, but he shall keep the Chief Minister informed about the same. Notwithstanding anything in the foregoing provisions of this clause, the final decision on all matters relating to Tensang district shall be made by the Governor in his discretion. In Articles 54 and 55 and Clause 4 of Article 80, references to the elected members of the Legislative Assembly of a state or to each such member shall include references to the members or member of the Legislative Assembly of Nagaland elected by the Regional Council established under this article. In Article 170, Clause 1 shall, in relation to the Legislative Assembly of Nagaland, have effect as if for the word 60, the word 46 had been substituted. In the said clause, the reference to direct election from territorial constituencies in the state shall include election by members of Regional Council established under this article. In clauses 2 and 3, reference to territorial constituency shall mean references to territorial constituencies in Kohima and Mokchung districts. If any difficulty arises in giving effect to any of the foregoing provisions of this article, the President may by order do anything, including any adaptation or modification of any other article, which appears to him to be necessary for the purpose of removing that difficulty, provided that no such order shall be made after the expiration of 3 years from the date of formation of the state of Nagaland. Explanation: in this article, the Kohima, the Mokchung and Tensang districts shall have same meanings as in the State of Nagaland Act 1962. Article 371b, special provision with respect to the state of Assam. Notwithstanding anything in this constitution, President may, by order made with respect to the state of Assam, provide for the constitution and functions of a committee of Legislative Assembly of the state, consisting of members of that assembly elected from the tribal area specified in Part 1 of the table appended to paragraph 20 of the 6th schedule, and such number of other members of that assembly as may be specified in the order, and the modifications to be made in the rules of procedure of that assembly for the constitution and proper functioning of such committee. Article 371c, special provision with respect to the state of Manipur. Notwithstanding anything in this constitution, the President may by order made with respect to the state of Manipur provide for the constitution and functions of a committee of the Legislative Assembly of the state, consisting of members of that assembly elected from the hill areas of that state, for the modifications to be made in the rules of business of the government and in the rules of procedure of the Legislative Assembly of the state, and for any special responsibility of the governor in order to secure the proper functioning of such committee. The governor shall annually, or whenever so required by the President, makes a report to the President regarding the administration of the hill areas in the state of Manipur, and the executive power of the Union shall extend to the giving of directions to the state as to the administration of the said areas. Explanation: in this article, the expression hill areas means such areas as the President may, by order, declare to be hill areas. Article 371d, special provisions with respect to the state of Andhra Pradesh and the state of Telangana. The President may, by order made with respect to the state of Andhra Pradesh or the state of Telangana, provide, having regard to the requirement of each state, for adequate opportunities and facilities for the people belonging to different parts of such state in the matter of public employment and in the matter of education, and different provisions may be made for various parts of the states. An order made under Class 1 may in particular require the state government to organize any class or classes of post in civil service or any class or classes of civil post under the state into different local cadres for different parts of the state, and allot in accordance with such principles and procedure as may be specified in the order the persons holding such post to the local cadre so organized. Specify any part or parts of the state which shall be regarded as the local area. For different recruitment to post in any local cadre, whether organized in pursuance of an order under this article or constituted otherwise under the state government. For direct recruitment to post in any cadre under any local authority within the state, and for the purposes of admission to any university within the state, or to any other educational institution which is subject to the control of the state government. Specify the extent to which, the manner in which, and the conditions subject to which preference or reservation shall be given or made. In the matter of direct recruitment to post in any such cadre referred to in subclause B, as may be specified in this behalf in the order. In the matter of admission to any such university or other educational institution referred to in subclass B, as may be specified in this behalf in the order, to or in favor of candidates who have resided or studied for any period specified in the order in the local area in respect of such cadre, university or other educational institution as the case may be. The President may, by order, provide for the constitution of an administrative tribunal for the state of Andhra Pradesh and for the state of Telangana to exercise such jurisdiction, powers and authority, including any jurisdiction, power and authority which immediately before the commencement of the Constitution, 32nd Amendment Act 1973, was exercisable by any court other than the Supreme Court or by any tribunal or authority as may be specified in the order with respect to the following matters, namely appointment, allotment or promotion to such class or classes of post in any civil service of the state, or to such class or classes of civil post under the state, or to such class or classes of post under the control of any local authority within the state as may be specified in the order. Seniority of persons appointed, allotted or promoted to such class or classes of post in any civil service of the state, or to such class or classes of civil post under the state, or to such class or classes of post under the control of any local authority within the state as may be specified in the order. Such other conditions of service of persons appointed, allotted or promoted to such class or classes of post in any civil service of the state, or to such class or classes of civil post under the state, or to such class or classes of post under the control of any local authority within the state as may be specified in the order. An order made under Clause 3 may authorize the administrative tribunal to receive representations for the redress of grievances relating to any matter within its jurisdiction as the President may specify in the order, and to make such orders thereon as the administrative tribunal deems fit. Contains such provisions with respect to the powers and authorities and procedures of the administrative tribunal, including provisions with respect to the powers of the administrative tribunal to punish for contempt of itself as the President may deem necessary. Provide for the transfer to the administrative tribunal of such classes of proceedings, being proceedings related to matters within its jurisdiction and pending before any court other than Supreme Court or tribunal or other authority immediately before the commencement of such order as may be specified in the order. Contain such supplemental, incidental and subsequential provisions, including provisions as to fees and as to limitation, evidence, or for the application of any law for the time being in force, subject to any exceptions or modifications as the President may deem necessary. The order of the Administrative Tribunal finally disposing of any case shall become effective upon its confirmation by the state government, or on the expiry of 3 months from the date on which the order is made, whichever is earlier, provided that the state government may, by special order made in writing and for reasons to be specified therein, modify or annul any order of the Administrative Tribunal before it becomes effective, and in such a case, the order of the Administrative Tribunal shall have effect only in such modified form, or be of no effect, as the case may be. Every special order made by the state government under the proviso to clause 5 shall be laid as soon as may be after it is made before both houses of the state legislature. The High Court for the state shall not have any powers of superintendence over the Administrative Tribunal, and no court other than Supreme Court or tribunal shall exercise any jurisdiction, power, or authority in respect of any matter subject to the jurisdiction, power, or authority of, or in relation to the Administrative Tribunal. If the President is satisfied that the continued existence of Administrative Tribunal is not necessary, the President may by order abolish the Administrative Tribunal and make such provisions in such order as he may deem fit to for the transfer and disposal of cases pending before the tribunal immediately before such abolition. Notwithstanding any judgment, decree, or order of any court, tribunal, or other authority, no appointment, posting, promotion, or transfer of any person made before the first day of November 1956 to any post under the government of or any local authority within the state of Hyderabad as it existed before that date, or made before the commencement of the Constitution 32nd Amendment Act 1973 to any post under the government of or any local or other authority within the state of Andhra Pradesh, and no action taken or thing done by or before any person referred to in subclause A shall be deemed to be illegal or void, or ever to have become illegal or void merely on the ground that the appointment, posting, promotion, or transfer of such person was not made in accordance with any law then in force, providing for any requirement as to residence within the state of Hyderabad, or as the case may be within any part of the state of Andhra Pradesh in respect of such appointment, posting, promotion, or transfer. The provisions of this article and of any order made by the President thereunder shall have effect notwithstanding anything in any other provision of this Constitution or in any other law for the time being in force. Article 371E. Establishment of Central University in Andhra Pradesh. Parliament may by law provide for the establishment of a university in the state of Andhra Pradesh. Article 371F. Special provisions with respect to the state of Sikkim. Notwithstanding anything in this Constitution, the Legislative Assembly of the state of Sikkim shall consist of not less than 30 members. As from the date of commencement of the Constitution, 36th Amendment Act 1975, hereinafter in this article referred to as appointed day. The Assembly for Sikkim formed as a result of elections held in Sikkim in April 1974, with 32 members elected in the state in the said elections, hereinafter referred to as sitting members, shall be deemed to be the Legislative Assembly of the state of Sikkim, duly constituted under this Constitution. The sitting members shall be deemed to be the members of the Legislative Assembly of the state of Sikkim, duly elected under this Constitution, and the said Legislative Assembly of the state of Sikkim shall exercise the powers and perform the functions of the Legislative Assembly of a state under this Constitution. In the case of Assembly deemed to be the Legislative Assembly of the state of Sikkim under Clause B, the references to the period of 5 years in Clause 1 of Article 172 shall be construed as references to a period of 4 years, and the said period of 4 years shall be deemed to commence from the appointed day. Until other provisions are made by Parliament by law, there shall be allotted to the state of Sikkim 1 seat in the House of People, and the state of Sikkim shall form one parliamentary constituency to be called the Parliamentary Constituency for Sikkim. The representative of the state of Sikkim in the House of People in existence on the appointed day shall be elected by the members of the Legislative Assembly for the state of Sikkim. Parliament may, for the purpose of protecting the rights and interests of the different sections of the population of Sikkim, make provision for the number of seats in the Legislative Assembly of the state of Sikkim, which may be filled by candidates belonging to such sections, and for the delimitation of the assembly constituencies from which candidates belonging to such sections alone may stand for election to the Legislative Assembly of the state of Sikkim. The Governor of Sikkim shall have special responsibility for peace and for an equitable arrangement for ensuring the social and economic advancement of different sections of the population of Sikkim. And in the discharge of his special responsibility under this clause, the Governor of Sikkim shall subject to such directions as the President may, from time to time, deem fit to issue act in his discretion. All property and assets, whether within or outside the territories comprised in the state of Sikkim, which immediately before the appointed day were vested in the government of Sikkim or in any other authority or in any person for the purposes of the government of Sikkim shall, as from the appointed day, vest in the government of the state of Sikkim. The High Court functioning as such immediately before the appointed day in territories comprised in the state of Sikkim shall, on and from the appointed day, be deemed to be the High Court for the state of Sikkim. All courts of civil, criminal, and revenue jurisdiction, all authorities and all officers, judicial, executive, and ministerial throughout the territory of the state of Sikkim shall continue on and from the appointed day to exercise their respective functions subject to the provisions of this constitution. All laws in force immediately before the appointed day in the territories comprised in the state of Sikkim or any part thereof shall continue to be in force therein until amended or repealed by a competent legislature or other competent authority. For the purpose of facilitating the application of any such law as is referred to in clause K in relation to the administration of the state of Sikkim, and for the purpose of bringing the provisions of any such law into accord with the provisions of this constitution, the President may, within 2 years from the appointed day, by order, make such adaptations and modifications of the law, whether by way of repeal or amendment, as may be necessary or expedient, and thereupon every such law shall have effect subject to the adaptations and modifications so made, and any such adaptation or modification shall not be questioned in any court of law. Neither the Supreme Court nor any other court shall have jurisdiction in respect of any dispute or other matter arising out of any treaty, agreement, engagement, or other similar instrument relating to Sikkim, which was entered into or executed before the appointed day, and to which the Government of India or any of its predecessor government was a party. But nothing in this clause shall be construed to derogate from the provisions of Article 143. The President may, by public notification, extend such restrictions or modifications as he thinks fit to the state of Sikkim any enactment which is in force in a state in India at the date of the notification. If any difficulty arises in giving effect to any of the foregoing provisions in this article, the President may, by order, do anything, including any adaptation or modification of any other article which appears to him to be necessary for the purpose of removing the difficulty, provided that no such order shall be made after the expiry of 2 years from the appointed day. All things done and all actions taken or in relation to the state of Sikkim or territories comprised therein during the period commencing on the appointed day and ending immediately before the date on which the Constitution 36th Amendment Act 1975 receives the assent of the President shall, insofar as they are in conformity with the provisions of this Constitution as amended by the Constitution 36th Amendment Act 1975, be deemed to for all purposes to have been validly done or taken under this Constitution so amended. Article 371G, special provision with respect to the state of Mizoram. Notwithstanding anything in this Constitution, no act of Parliament in respect of religious or social practices in the MISOs. MISO, customary law and procedure, administration of civil and criminal justice involving decisions according to MISO customary law. Ownership and transfer of land shall apply to the state of Mizoram unless the Legislative Assembly of the state of Mizoram by a resolution so decides, provided that nothing in this clause shall apply to any central act in force in the Union Territory of Mizoram immediately before the commencement of this Constitution. 53rd Amendment Act 1986. The Legislative Assembly of the State of Mizoram shall consist of not less than 40 members. Article 371H. Special provision with respect to the state of Arunachal Pradesh. Notwithstanding anything in this Constitution, the Governor of Arunachal Pradesh shall have special responsibility with respect to law and order in the state of Arunachal Pradesh, and in the discharge of his functions in relation thereto, the Governor shall, after consulting the Council of Ministers, exercise his individual judgment as to the action to be taken, provided that if any question arises whether any matter is or is not a matter as respect which the Governor is under this clause required to act in the exercise of his individual judgment, the decision of the Governor in his discretion shall be final, and the validity of anything done by the Governor shall not be called in question on the ground that he ought or ought not to have acted in the exercise of his individual judgment. Provided further that the President, on receipt of a report from the Governor, or otherwise is satisfied that it is no longer necessary for the Governor to have special responsibility with respect to law and order in the state of Arunachal Pradesh, he may, by order, direct that the Governor shall cease to have such responsibility with effect from such date as may be specified in the order. The Legislative Assembly of the state of Arunachal Pradesh shall consist of not less than 30 members. Article 371I. Special provision with respect to the state of Goa. Notwithstanding anything in this Constitution, the Legislative Assembly of the state of Goa shall consist of not less than 30 members. Article 371J. Special provision with respect to the state of Karnataka. The President may, by order made with respect to the state of Karnataka, provide for any special responsibility of the Governor for establishment of a separate development board for Hyderabad Karnataka region, with the provision that a report on the working of the board will be placed each year before the State Legislative Assembly. Equitable allocation of funds for developmental expenditure over the said region, subject to the requirements of the state as a whole, and equitable opportunities and facilities for the people belonging to the said region in matters of public employment, education, and vocational training, subject to the requirements of the state as a whole. An order made under subclause C of Clause 1 may provide for reservation of a proportion of seats in educational and vocational training institutions in the Hyderabad Karnataka region for students who belonging to that region by birth or by domicile. An identification of post or classes of post under the state government and in any body or organization under the control of the state government in the Hyderabad Karnataka region, and reservation of a proportion of such post for persons who belonging to that region by birth or by domicile, and for appointment thereto by direct recruitment or by promotion or in any other manner as may be specified in the order. Article 372. Continuance in force of existing laws and their adaptation. Notwithstanding the repeal by this Constitution of enactments referred to in Article 395, but subject to the other provisions of this Constitution, all the law in force in the territory of India immediately before the commencement of this Constitution shall continue in force therein until altered or repealed or amended by a competent legislature or other competent authority. For the purpose of bringing the provisions of any law in force in the territory of India into accord with the provisions of this Constitution, the President may by order make such adaptations and modifications of such law, whether by way of repeal or amendment, as may be necessary or expedient, and provide that the laws shall, as from such date, as may be specified in the order, have effect subject to the adaptations and modifications so made, and any such adaptation or modification shall not be questioned in any court of law. Nothing in clause 2 shall be deemed to empower the President to make any adaptation or modification of any law after the expiration of 3 years from the commencement of this Constitution, or to prevent any competent legislature or other competent authority from repealing or amending any law adapted or modified by the President under the said clause. Explanation 1. The expression law in force in this article shall include a law passed or made by a legislature or other competent authority in the territory of India before the commencement of this Constitution and not previously repealed, notwithstanding that it or parts of it may not be then in operation either at all or in particular areas. Explanation 2. Any law passed or made by a legislature or other competent authority in the territory of India, which immediately before the commencement of this Constitution had extraterritorial effect as well as effect in the territory of India, shall subject to any such adaptations and modifications as aforesaid continue to have such extraterritorial effect. Explanation 3. Nothing in this article shall be construed as continuing any temporary law in force beyond the date fixed for its expiration or the date on which it would have expired if this Constitution had not come into force. Explanation 4. An ordinance promulgated by the Governor of the province under Section 88 of the Government of India Act 1935 and in force immediately before the commencement of this Constitution shall, unless withdrawn by the Governor of the corresponding state earlier, cease to operate at the expiration of 6 weeks from the first meeting after such commencement of the Legislative Assembly of that state functioning under Clause 1 of Article 382, and nothing in this article shall be construed as continuing any such ordinance in force beyond the said period. Article 372A. Power of the President to adapt laws. For the purposes of bringing the provisions of any law in force in India, or in any part thereof, immediately before the commencement of the Constitution, 7th Amendment Act 1956, into accord with the provisions of this Constitution as amended by that Act, the President may, by order made before the first day of November 1947, make such adaptations and modifications of the law, whether by way of repeal or amendment, as may be necessary or expedient, and provide that the law shall, as from such date as may be specified in the order, have effect subject to the adaptations and modifications so made, and any such adaptation or modification shall not be questioned in any court of law. Nothing in Clause 1 shall be deemed to prevent a competent legislature or other competent authority from repealing or amending any law adapted or modified by the President under the said clause. Article 373. Power of President to make order in respect of persons under preventive detention in certain cases. Until provision is made by President under Clause 7 of Article 22, or until the expiration of 1 year from the commencement of this Constitution, whichever is earlier, the said article shall have effect as if for any reference to Parliament in Clause 4 and 7 thereof, they were substituted a reference to the President, and for any reference to any law made by Parliament in those clauses, there were substituted a reference to an order made by the President. Article 374. Provisions as to judges of Federal Court and proceedings pending in Federal Court or before His Majesty in Council. The judges of the Federal Court holding office immediately before the commencement of this Constitution shall, unless they have elected otherwise, become on such commencement the judges of the Supreme Court, and shall thereupon be entitled to such salaries and allowances, and to such rights in respect of leave of absence and pension as are provided under Article 125 in respect to the judges of the Supreme Court. All suits, appeals, proceedings, civil or criminal, pending in the Federal Court at the commencement of this Constitution shall stand removed to the Supreme Court, and the Supreme Court shall have jurisdiction to hear and determine the same, and the judgments and orders in the federal court delivered or made before the commencement of this Constitution shall have the same effect as if they had been delivered or made by the Supreme Court. Nothing in this Constitution shall operate to invalidate the exercise of jurisdiction by His Majesty in Council to dispose of appeals and petitions from or in respect of any judgment, decree, or order of any court within the territory of India, insofar as the exercise of such jurisdiction is authorized by law, and any order of His Majesty in Council made on any such appeal or petition of the commencement of this Constitution shall for all purposes have effect as if it were an order or decree made by the Supreme Court in the exercise of the jurisdiction conferred on such court by this Constitution. On and from the commencement of this Constitution, the jurisdiction of the authority functioning as the Privy Council in a state, specified in Part B of the first schedule, to entertain and dispose of appeals and petitions from or in respect of any judgment, decree, or order of any court within the state shall cease, and all appeals and other proceedings pending before the said authority at such commencement shall be transferred to and disposed of by the Supreme Court. Further provision may be made by Parliament by law to give effect to the provisions of this article. Article 375. Courts, authorities, and officers to continue to function subject to the provisions of this Constitution. All courts of civil, criminal, and revenue jurisdiction, all authorities and all officers, judicial, executive, and ministerial throughout the territory of India shall continue to exercise their respective functions subject to the provisions of this Constitution. Article 376. Provisions as to judges of high courts. Notwithstanding anything in Clause 2 of Article 270, the judges of High Court in any province holding office immediately before the commencement of this Constitution shall, unless they have elected otherwise, become on such commencement the judges of the High Court in the corresponding state, and shall thereupon be entitled to such salaries and allowances and to such rights in respect of leave of absence and pension as are provided for under Article 231 in respect of the judges of such High Court. Any such judge shall, notwithstanding that he is not a citizen of India, be eligible for appointment as Chief Justice of such High Court, or as Chief Justice or other judge of any other High Court. The judges of a High Court in any Indian state corresponding to any state specified in Part B of the first schedule, holding office immediately before the commencement of this Constitution, shall, unless they have elected otherwise, become on such commencement the judges of the High Court in the state so specified, and shall, notwithstanding anything in Clause 1 and 2 of Article 217, but subject to the proviso to Clause 1 of that article, continue to hold office until the expiration of such period as the President may by order determine. In this article, the expression judge does not include an acting judge or an additional judge. Article 377. Provisions as to Controller and Auditor General of India. The Auditor General of India, holding office immediately before the commencement of this Constitution, shall, unless he has elected otherwise, become on such commencement the Controller and Auditor General of India, and shall thereupon be entitled to such salaries and to such rights in respect of leave of absence and pension as are provided for under Clause 3 of Article 148 in respect of the Controller and Auditor General of India, and be entitled to continue to hold office until the expiration of his term of office as determined under the provisions which were applicable to him immediately before such commencement. Article 378. Provisions as to Public Service Commissions. The members of the Public Service Commission for the Dominion of India holding office immediately before the commencement of this Constitution shall, unless they have elected otherwise, become on such commencement the members of the Public Service Commission for the Union, and shall, notwithstanding anything in Clause 1 and 2 of Article 316, but subject to the proviso to Clause 2 of that article, continue to hold office until the expiration of their term of office as determined under the rules which were applicable immediately before such commencement to such members. The members of Public Service Commission of a province or of a Public Service Commission serving the needs of a group of provinces holding office immediately before the commencement of this Constitution shall, unless they have elected otherwise, become on such commencement the members of the Public Service Commission for the corresponding state, or the members of the Joint State Public Service Commission serving the needs of the corresponding state, as the case may be, and shall, notwithstanding anything in Clause 1 and 2 of Article 316, but subject to the proviso to Clause 2 of that article, continue to hold office until the expiration of their term of office as determined under rules which were applicable immediately before such commencement to such members. Article 378A. Special provision as to duration of Andhra Pradesh Legislative Assembly. Notwithstanding anything contained in Article 172, the Legislative Assembly of the State of Andhra Pradesh, as constituted under the provisions of Sections 28 and 29 of the State Reorganization Act 1946, shall, unless sooner dissolved, continue for a period of 5 years from the date referred to in the said Section 29, and no longer at the expiration of the said period shall operate as a dissolution of that Legislative Assembly. Article 392. Power of the President to remove difficulties. The President may, for the purpose of removing any difficulties, particularly in relation to the transition from the provision of the Government of India Act 1935 to the provisions of this Constitution, by order direct that this Constitution shall, during such period as may be specified in the order, have effect subject to such adaptations, whether by way of modification, addition or omission, as he may deem to be necessary or expedient, provided that no such order shall be made after the first meeting of Parliament, duly constituted under Chapter 2 of Part 5. Every order made under Clause 1 shall be laid before Parliament. The powers conferred on the President by this article, by Article 324, by Clause 3 of Article 367, and by Article 391 shall, before the commencement of this Constitution, be exercisable by the Governor General of the Dominion of India. Short title: Commencement, authoritative text in Hindi and repeals. Article 393, short title: This Constitution may be called the Constitution of India. Article 394, Commencement. This article and Articles 5, 6, 7, 8, 60, 324, 366, 367, 379, 380, 388, 391, 392, and 393 shall come into force at once, and the remaining provisions of this Constitution shall come into force on the 26th day of January 1950. Which day is referred to in this Constitution as the commencement of this Constitution. Article 394A, authoritative text in Hindi language. The President shall cause to be published under his authority the translation of this Constitution in the Hindi language signed by the members of the Constituent Assembly, with such modifications as may be necessary to bring it in conformity with the language, style, and terminology adopted in the authoritative text of central acts in the Hindi language, and incorporation therein all the amendments of this constitution made before such publication, and the translation in the Hindi language of every amendment of this constitution made in the English language. The translation of this constitution and of every amendment thereof published under clause 1 shall be construed to have the same meaning as the original thereof, and if any difficulty arises in so construing any part of such translation, the President shall cause the same to be revised suitably. The translation of this constitution and of every amendment thereof published under this article shall be deemed to be for all purposes the authoritative text thereof in the Hindi language. Article 395 repeals the Indian Independence Act 1947 and the Government of India Act 1935, together with all enactments amending or supplementing the latter act, but not including the abolition of Privy Council Jurisdiction Act 1949, are hereby repealed.